Reasons for a prenuptial. It is very common for people to view marriage as a business partnership and want to spell out their financial relationship. Because divorce is a fact of life, many couples want a prenuptial agreement before saying "I do," to minimize disputes if a divorce should occur. Additionally, because second and third marriages are common, many couples want a prenuptial to preserve assets for existing children of prior marriages. Complicated and technical. The rules regarding the validity of a prenuptial agreement are very technical and complicated. This is one area where you should retain an attorney. Concepts. This video will not go over the technical family law rules that apply to creating a valid prenuptial agreement, but rather will go over the concepts that guide those rules. If you understand the concepts, it will be easier to understand the rules. 4 basic conceptual requirements. There are 4 basic conceptual requirements for a valid prenuptial agreement. First, there must be full financial disclosure between the parties. 2, each party should be represented by an attorney. 3, the prenuptial agreement should be signed well in advance of the wedding so that the signing party is not under duress or pressure to sign the prenuptial at the last minute. 4, the agreement must not be against public policy. Full financial disclosure. Full disclosure means that each party must disclose all income, assets, and debts in writing to the other party. The standard to meet the full financial disclosure requirement is twofold. 1, the financial disclosures need to be precise, i.e., not vague generalities regarding income and the assets and debts. An example of an asset and debt disclosure is as follows. I own a house X located at 405 Lane Street, Boston, Massachusetts. It has a value of $400,000 and I owe a $300,000 mortgage. I have $15,000 in credit card debt, $5,000 with B of A, $5,000 with Chase, and $5,000 with Citibank. 2, the financial disclosures need to be updated if there are changes up to the date a party signs the prenuptial, modifying the existing community property law. Property at the time of marriage. Prenuptial agreements help identify separate property of each party before they get married. Representation by an attorney. Each party should be represented by an attorney. The parties cannot share a joint attorney. They must have separate attorneys. Each attorney must explain to each party their rights and obligations under the prenuptial agreement. The attorney will explain to their respective client the effect of the prenuptial agreement, especially what each party is giving up, and if the prenuptial agreement changes existing community property law, including earnings during the marriage. Attention! If one party does not want to be represented by an attorney, very special and specific family law rules must be followed. No duress. One common challenge against the validity of a prenuptial agreement is duress or pressure, because the prenuptial was signed at the last minute. It is therefore best to sign the prenuptial agreement as far in advance of the wedding as possible, i.e., long before the wedding date and the wedding invitations are sent out, so later there's no claim of duress. It is unfair to present a prenuptial agreement to the bride or groom as they are walking down the aisle. Terms against public policy. The terms of the prenuptial agreement must not be against public policy. For example, people cannot waive the obligation to pay child support. Waiving child support is against public policy. However, a waiver of future spousal support is not in and itself void and against public policy or unenforceable. Attention! If one or both parties are waiving future spousal support, very special and specific family law rules must be followed. Changing the existing community property law. A prenuptial agreement can change the operation of the existing applicable community property laws, regarding income and property. A prenuptial agreement can change existing community property laws to ensure that earnings and property of each party remain the separate property of the earner-owner. For example, once a person gets married, normally that person's income or salary becomes community property. The parties can agree that their respective income and salary will remain their separate property income and salary, and that no community property income or salary is created. Takeaways. Prenuptial agreements are becoming very common as couples want to spell out their financial relationship. The family law rules regarding how to create a valid prenuptial agreement are very technical, and you should seek the legal advice of a competent attorney. There are 4 key concepts behind the technical rules. First, full financial disclosure. 2, avoidance of duress. 3, representation by an attorney. And 4, no terms in the agreement against public policy. Was this video helpful for you? Please let us know by liking this video. And if you have any questions or suggestions for topics, leave us a comment. We also offer a variety of resources such as attorney referrals and legal checklists over at our website, utkdivorce.com. And last, subscribe. We provide new videos every week that you don't want to miss, and your subscription shows us your support. See you next time.